Okay, we are now live. We're here on the matter of Airway Welding versus Rick Rogers et al. Counsel, would you each state your appearances, please?
Joseph Spiegel for the Rogers family.
Paul Bernard for the Rogers family.
Good afternoon, Your Honor. Bruce Inocencio on behalf of plaintiffs and counter defendants.
Good afternoon, Your Honor. Christina Fisk, also on behalf of the plaintiffs' counter defendants.
So before we wade into the mountain of legal issues that you brought in front of me today, where do you see this headed?
Your Honor, may I?
Go ahead.
The original problem was Doug wants to buy out Rick. Rick doesn't want to sell at the price Doug wants to pay.
I'm going to object to that, Your Honor. That's not accurate.
And I have a possible solution. Mr. Bernard and I have talked about it. I would propose to have Doug and Rick start two companies within Airway. And I would then have one of their major customers give each of them some orders sufficient for each of the two companies to become certified. There's a certification process. It's pretty complicated, but very simple. For example, Doug or Rick certify the welders, and then a certification entity certifies to the customer, the company, and that it is capable of performing the services in an appropriate manner. Because it's aerospace, it's welding, there's certain standards. And then, once both Rick and Doug, their new companies, are both certified, then we can have a start date. They can divide up the money, sell the building, sell the assets, and God be with everybody. It's a pretty simple solution, and we have two individuals that I believe can assist in this. One is Robert Schwartz, who's been the company lawyer forever, or Gary Soretsky, who has been the mediator, and if things don't get resolved, I would hope that Bruce would agree that he could be a discovery master if that was something the court would want. I think that that's a rational, reasonable approach to this situation, given the uncertain times, because it takes about, from what I understand, anywhere from 4 to 6 months to get certified. So, given the very unusual circumstances as we find ourselves in today, I think that would take care of the problem. That way, Rick doesn't have to take a price he doesn't want, and Doug doesn't have to pay what he doesn't want, and they both can be certified, and they both can do whatever they want. If they want to get business, they'll get business. If they don't want to get business, they don't have to get business. They'll be equal. Now, it's difficult for me to communicate with Bruce at times. Bruce and I have difficulty with the telephone. I'm not sure why. But I think that Mr. Bernard and I, and we talked to our client in the parking lot before we came up here, and they're amenable to that. I think it's a solution. And we could put all the litigation on hold for whatever time it takes for each of these two new codes to get certified. There we go.
what you're suggesting as a resolution is something that if the parties were able to agree on, they could reach a resolution along that path. Doesn't sound like anything I can make happen.
Well, maybe Your Honor could encourage one side or the other that may not be agreeable to give it some very, very serious consideration. I don't know what Bruce thinks about this.
May I respond, Your Honor?
If you wish, you may.
Your Honor, to begin, I think the court just touched on it. The court doesn't have the authority to do this, number one. Number two, this is the first I've heard of this option. Number three, it sounds like it's a settlement offer of some sort that probably shouldn't be brought into court for discussion with the trier of that here. And that's exactly what just happened. We have been in a corporate deadlock scenario for 5 years. 2015, we tried to resolve it with Mr. Soretsky last, I think it was August. I think Mr. Soretsky did a fantastic job, frankly, under the circumstances.
So, well, what are they deadlocked with? They're deadlocked over the issue of a buyout. They don't seem to be deadlocked in terms of running the company if they've kept the doors open for 5 years.
We would disagree with that. In fact, there are a number of situations that Doug Rogers, our client, has tolerated and handled and dealt with just to continue operations moving forward. For example, this court, when we were here March 3rd, said, and I'm paraphrasing, but the court, I'm sure, has reviewed the transcript that we attached. No checks written. No, don't spend any money outside the ordinary course of business. The next day, we get a letter from opposing counsel saying we need to pull $800,000 a piece out of the company. But the company cannot afford that. Every day, there are issues that the parties cannot resolve. When their father passed away, they went from a 3-person board to a 2-person board with 50-50 ownership. My client has been trying to extract himself from this scenario, either as the buyer or the seller, and that's why I objected. My client is saying it has to be my way, I have to be the buyer, or I have to be the seller. That's not the case at all. There's a willingness to look at both options. Mr. Soretsky attempted to mediate a resolution. I'm not obviously going to get into what happened at mediation because that would be wholly inappropriate, but we aren't there, and we tried, and we were willing to try immediately. When this court ordered us to participate in mediation, within an hour of being here, I contacted Mr. Soretsky and asked him to become involved again. An hour later, I received a facsimile that says, oh, we'll make ourselves available after April 20th. That's 6 weeks later. The court only gave us 8.5 weeks. We did what we could to resolve it in August. We did what we could to resolve it last month, or a month and a half ago. We are not creating an impasse. The mediator is saying, I can't get you there. You're too far apart. We cannot make it happen. What the authority scope is here for the court is dissolution and appointment of a receiver. To have what has been alluded to as Airways corporate counsel step in and get involved, he was the person that drafted the proposed buyout agreement back in 2015 that my client agreed to, and that Mr. Rogers, Ricky Rogers, would not agree to. If they cannot agree on the attorney, they cannot agree on the buyout, here's what's going to happen. My client is ready to retire in one way, shape, or another. Either he'll continue the company with his sons, if he's the purchaser, or he'll sell it. And he gets to retire. But if this court doesn't follow the statute providing for dissolution, this court is literally chaining him to his brother forever. He cannot get out of this company. This is, even though it's a corporation, it's tantamount to a partnership. And there's Michigan case law on point. You have a 50-50 situation. You don't have a buyout. You have corporate deadlock. My client cannot retire unless he does exactly what his brother says, this is what's going to happen. He doesn't want to do that. He wants to reach a resolution. They can't get there. This is why we have dissolution. This is why this court said, I've seen enough. back on March 3rd. I don't need to go to trial. I don't need all this discovery. Let's go forward. You have 60 days. You resolve it or I'm going to. You're not going to like it. Both parties knew what would happen then. There's no need for an extension. The order that was requested by this court to have been prepared by opposing counsel within 10 days was never prepared. That's why we submitted one. And that's why we included all the language that the court will require relative to appointment of a receiver. We recognize that there are issues set forth in that order that were not stated on the record that day. But when the court says, I'm going to appoint a receiver, this court obviously has to follow the court rule and follow the statute. So we included all of those steps. Their objection was not that we prepared an order that didn't reflect the court's ruling. Their objection was, oh, we want to extend the statute status quo. That's not how you object to a proposed order on the 7-day. You have to submit an order that reflects what you believe the court ordered that day. This can't come out to a motion for reconsideration. We've made no progress. We tried, but we've made no progress. It's time for the court to say, none of this other stuff needs to happen. We're going to appoint a receiver. We're going to let the receiver handle all the legal issues or engage outside counsel. And let the chips fall where they may. If Mr. Rogers, Ricky, wants to buy the company through the receivership, he can do that. If my client wants to, he can do that. But they're not going to get there via mediation, unfortunately. We've tried. I mean, Judge, when I say we tried, multiple days, hours at length sometimes on Zoom calls. And I don't know how much time that they spent on the call, and I'm not going to get into that. And I trust that they put forth a good effort in mediation. But we're not there. And it's not for lack of trying. We need the court to intervene. Thank you.
First of all, Your Honor, this is a jury trial. So you are perfectly capable of listening to settlement, and I encourage you to get involved in settlement. You're not going to be trying this case without a jury. Now, I do understand that there are impediments to jury trials as we sit here today that never existed when we were back here in March. The world has changed dramatically. But contrary to Doug Rogers' counsel, the affidavit says that he wants to buy out Rick Rogers. That's what he wants. He wants to buy out Rick Rogers at a price that is not what Rick Rogers wants. Okay, that's not a basis for a receivership. You need to have a factual finding that there is an actual dispute. Now, we've just submitted declarations, 3 of them. And those declarations are pretty clear. One, the company in January, February, March, April, and May is making money. Those declarations specifically say there's no real controversy. The only controversy is Doug wants to pay a price that Rick doesn't want. Well, okay. And Doug could walk out of the business tomorrow, give up everything in the way of administration, and still collect 50% of the business's profits. Why doesn't he do that? What he wants is a price that is cheap and force Rick out of the business and essentially not let him continue his lifetime work, because Doug wants the certification, Doug wants Airways, Doug wants it on the cheap. Okay, just because you want something doesn't mean you're going to get it. And I think we have to deal with this disqualification issue. Now, I soft-pedaled the disqualification right from the beginning. The company has an attorney. Unfortunately, Bruce misconstrues the 2 cases he cited. One of those involves a friend of mine, Harvey Wax. And in that case, they kind of severed that issue. But there was really no disqualification. The other case, there was a consent between the parties, and therefore no disqualification. In this case, if you look at the complaint, Bruce's clients want damages from Rick, a 50% partner. And the case law is, and the ethics rules are abundantly clear. He can't do that. He claims it's a technicality. It's not a technicality. This is a corporation with two partners, just like in the Summer Schwartz case. And this is a company with individuals. And this is a company that has an existence. And Bruce just can't keep representing the company. So if Bruce doesn't want to take back to his client this proposal to have the two companies hiatus for 6 months, then a start date, have Mr. Schwartz or Mr. Soretsky oversee this process, then I would suggest we continue this matter so we can take some discovery, because the case is not going to end today. Even if it's dissolved, even if a receiver is appointed, we have the following claims against Doug: shareholder oppression, breach of fiduciary duty, tortious interference with contract, breach of contract by Doug, and a declaratory judgment which may not happen. The case is going to continue. It is not just going to evaporate. And that's the problem with the disqualification, which will take, and I don't know if Mr. Schwartz, as the corporate attorney, is going to step in. Is he going to say, wait a second, I need an outside counsel? I've been doing this for 45 years, Your Honor, and I have never represented a company and a 50% partner against another 50% partner. When I saw that Summer Schwartz case, I said, whoa, that is serious.
So who would independent counsel take his direction from?
Well, that's an issue. He would make independent decisions for the corporation, whether it was to have a receiver appointed or to take charge or to force the parties.
I don't think that's an attorney's role.
Well, in these circumstances, it can be.
I mean,
He can ask that the
that
parties.
attorney would be effectively a receiver himself.
Somewhat. But you don't have the attendant problems. What I'm suggesting, Your Honor, is the company needs independent counsel. It can't have Bruce, from day one, taking a contrary position against a 50% partner. It's unethical. It can't be done. And you look at the complaint that Bruce submitted, and in count number 1, he asked for damages against the 50% partner. Count number 1, in excess of $25,000. So what does an independent attorney have to do? Well, he will independently assess the situation and advise the two directors, and they can or cannot take his advice. In the meantime, there's no basis for dissolution. None of the case law, not one single case, allows for the dissolution of a corporation where the only issue is one party wants to buy out the other. And all I'm suggesting is 90 days to take discovery, 90 days for an attorney to be appointed for the corporation, rule on the motion for a breach of fiduciary duty, the motion to dismiss, and we filed another motion, or a pleading that the court has, the ex parte motion, and we proceed like any other case. On 3 occasions, I've asked Bruce, here's the scheduling order of the court. Let's agree upon dates. This case is not going away. Just because your client wants dissolution doesn't mean everything just all of a sudden evaporates. It's just not going to happen. And that's why, and you can be involved in settlement. And I will tell you that we were frustrated by the process because, quite frankly, we thought one thing and we were communicated one thing, but when it came down to it, it is exactly what Doug says in his affidavit. I want to buy out Rick. But he doesn't want to buy out Rick for a price Rick feels is fair. And our expert Ben Bershad has some difficulty, given the financial crisis, at arriving at value of this company. We gave, within days, Bruce the value of the building. I don't know if it's still a valid valuation. But how are you going to value a company today when you don't know what's going to happen tomorrow?
But I would assume with a business of this nature that the building itself is a small piece of its value.
Yep,
I mean, we're looking at the value of a going concern.
exactly.
Where it actually sets up shop, probably doesn't have a huge bearing. Obviously, there's an asset value there, but in terms of the overall value, that's got to be a small piece of it.
It is, Your Honor, as is the equipment. The point here is, this is a company that's making money. This is a company that's making money for employees of the city of Jackson. This is a company that is making money for Bruce's family and for Rick's family. There's no basis for dissolution. You don't destroy the goodwill.
So your vision of what comes from a dissolution is the value's destroyed. All you
Yes.
got left is the value of the real estate and the value of its equipment and whatever its receivables are.
Why would you
Well,
want to
well,
kill
let me-
the goose that
let me
lays
finish.
golden eggs?
I can't imagine that that's what they want. It sounds like what they want to do is have not a liquidation in the sense of a fire sale, but a sale of the business as a going concern.
That's correct, Your Honor.
Well, how are you going to do that on a company that is owned by two shareholders? There's no market value. It's not like it's a NASDAQ company. It's not like it's a 12G reporting SEC corporation. There's no auction market where you can value it on the New York Stock Exchange. The only way you can get value is through expert testimony, and then this court would have to approve any sale based upon the experts, and the court may not approve the sale. So all I'm suggesting, Your Honor, is that at the very least, we should be able to take some discovery to determine what is the real basis for dissolution. Does it in fact exist? What is the basis for appointing a receiver? Does it in fact exist? We have a motion to dismiss the fiduciary breach count of the plaintiff. If that goes, it's the end of the case. And look, the case law specifically states on dissolution, just because people don't like each other doesn't give rise to a dissolution. It is a drastic remedy. Just like a receiver. Receiverships, as the court knows, started back in Henry VIII's time. And it was adopted in the United States. And the purpose of a receiver is to protect creditors where there is a wasting of assets. You don't have wasting of assets. You don't have any of the indicia. You don't have distressed real estate. You don't have any of the technical or rational elements to appoint a receiver in this case. The business is ongoing, it's getting business, it's putting out product, it's paying its employees. There's no creditor that is pushing to have a receivership. Now, quite frankly, Doug is free to go sell his business to a third party. Why doesn't he do that? Why doesn't Doug go out into the market and say, I want to sell my interest in the company? In which case there's a shareholder agreement and there's a specific process for doing that. No, he wants the business and he wants it cheap, and that's not the basis for dissolution or receivership. There's a shareholder agreement. It specifically states what you got to do if you sell to a third party, a bona fide third party. Let Doug, if he thinks it's a great deal, go sell it to Mr. Smith or Mr. Jones. We have no problem with that.
you're finding someone who's willing to buy a 50% interest in this corporation is what you're talking about?
Yes, it happens all the time, Your Honor. A bona fide offer, and Rick can say, all right, I got a right of first refusal, fine by me. Or he can say, no, Doug takes the money, and often he takes all his money and he can retire. But he can't force Rick to sell his stock at a price that Rick feels is not fair, just, and equitable. That is not what the case law says. You just have to, it's in our brief, Your Honor.
May I respond briefly, Your Honor?
You may.
Thank you. Thank you. Your Honor, there's, frankly, I think some confusion on the part of counsel relative to what this court has to look at to determine whether or not dissolution is appropriate. And the statute is clear. Section 823 of the Business Corporation Act, which is MCL 450.1823, at subsection A, explains what can happen in the event of dissolution. The entire statute reads as follows. A corporation may be dissolved by a judgment entered in an action brought in the circuit court of the county in which the principal place of business or registered office of the corporation is located, by one or more directors, or by one or more shareholders entitled to vote in an election of directors of the corporation upon proof of both of the following. A, the directors of the corporation, or its shareholders, if an agreement among the shareholders authorized by Section 488 is in effect, are unable to agree by the requisite vote on material matters respecting management of the corporation's affairs, or the shareholders of the corporation are so divided in voting power that they have failed to elect successors to any director whose term has expired or would have expired upon the election and qualification of his or her successor. That's happened. That's been in place for 5 years. They have failed to elect a successor for 5 years.
But they've still got directors.
They have 2. They're supposed to have 3, and they have failed to do that. And under subsection B, it says, as a result of a condition stated in subdivision A, the corporation is unable to function effectively in the best interests of its creditors and shareholders. Here's what we have, Your Honor. There's been a suggestion that there's been no wasting of assets. Your Honor, Ricky Rogers is allowing and condoning his sons to work all kinds of overtime, depleting the company of resources. Other employees are complaining about it. Morale is horrible among the workers that work at Airway that are not Rogers family members because Ricky is signing off on overtime that nobody else is getting. Every single day, Doug is having to do what he does, what he shouldn't have to do. Ricky is the treasurer. He's not handling the corporate finances. Doug is. We have an ongoing concern that there is a complete inability to get along. They do not effectively communicate. They fill, among the 2 of them, the only 2 shareholder roles and every officer role, and they don't communicate well. They cannot do it. So the reason that you have dissolution provided for by the statute is exactly for this scenario. The suggestion that there is an expert needed before you can sell the assets, there's no case law that states that. There's no case that says that you cannot, that this court does not have the authority to dissolve these entities unless there's a wasting of assets and everything that he went through. That doesn't say that. The case law that we set forth is pretty clear. You can have corporate deadlock, and that can be the basis for dissolution. The statute is pretty clear. There's no ambiguity in the statute. I have yet to see a case analyzing that statute that determined that the statute is ambiguous. This court has the authority. This court exercised that authority back on March 3rd. They're dragging their feet. I frankly don't understand it. But And I will explain why we've had some problems on the telephone. There have been a couple instances now where we've had discussions, Mr. Spiegel and I, and then something else happens that is completely different from the way it was explained to me. I communicate with very few attorneys by correspondence only. That's what's happening here. I don't believe that's the problem, though. The problem is Rick and Doug cannot communicate effectively. They cannot continue to run this business like this. Doug has been trying to resolve this issue for the benefit of the company for 5 years.
Is that when their father passed away, or?
Yes. So the problem that we have is to suggest that Doug wants to buy the company for a song. That's not true. That's not true. And I'm not going to get into the discussion that we had in mediation, but I can say we're not only looking at that as an option, and that was conveyed outside of mediation beforehand. What this court just heard from counsel was that there needs to be an independent counsel making decisions. That's a receiver. That's a receiver. That is exactly what we want to have happen. That's what this court ordered on March 3rd. I am going to say these companies are going to be dissolved, and I'm going to appoint a receiver. It's clear that you have corporate deadlock. Nothing has changed. There's no reason for this court to even be reconsidering right now its previous ruling. We've slid here into a motion for reconsideration. I'd like to understand why the order that we tendered to the court under the 7-day rule is not what should have been entered at this point. What is the basis for the objection? We didn't like the court's previous ruling? That's a motion for reconsideration. There's no basis for those objections. The order that we tendered to the court under MCR 2.602 should be entered by this court. There's no reason to go back on that. And to suggest that the whole case on our side evaporates if our breach of fiduciary duty claim falls, that's not true either. There's no basis. This is a complete deflection of the arguments. And I will say, relative to all of the claims that the defendants seem to have as a counterclaim, they all seem to stem from, we were terminated, we shouldn't have been terminated, and now we have damages. Let's go back to that for a second. This court ordered all of those parties to be reinstated. They were immediately reinstated. They were not denied access to anything, and they didn't lose a dime of their pay. They were all reinstated within less than a week. They're still working. They have no damages. I have a case with this court right now that I conducted a Zoom hearing on about 10 days ago. And I distinctly remember the other party suggesting that it would be inappropriate to award damages because damages had not actually been incurred by my client. And I recall this court suggesting, you know, it doesn't sound like damages have actually been incurred here. That's exactly what we have on all of their claims. It all relates to we were falsely terminated. We should not have been fired. There's no basis for that. This court said reinstate them. We reinstated them. Didn't lose a penny. Those claims should be gone right now. In fact, I would recommend that the court ask counsel, were any damages sustained? And if not, let's sua sponte dismiss those claims right now. There's no basis. This is not a cash machine that we just sit here as lawyers and continue to grind through this case unnecessarily. There's no reason to spend that money. There's no reason for discovery. This court's already determined very quickly we have corporate deadlock. The first thing I thought when I saw Your Honor walk out of chambers was the amount of paperwork you brought in here. We're just getting started. Why? Let's do what should be done. Let's follow the statute. Let's follow the court order. Let's follow the case law. Let's do the right thing and say, listen, we've given you 5 years to figure this out. You had an opportunity. You paid someone a lot of money twice to try to help you to resolve it, and you weren't able to do that. So now the court's going to intervene. We're tired of kicking the can down the road, and Doug Rogers, either as a buyer or as a seller, is going to be unchained from his brother. Thank you, Your Honor.
So, I'm assuming in the course of the mediation sessions that have taken place, there was a demand made and a response to the demand, and wherever it was you left. How far apart were you?
Well, here's the problem. We went to the second mediation session with the assurance that Doug was going to be a seller.
Your Honor, that's,
And-
no, Your Honor,
You know,
Your Honor,
Doug
I'm
was
gonna stop.
gonna
Your
be-
Honor, objection?
Bruce,
Your Honor,
Bruce,
Your
don't
Honor.
interrupt me.
All right,
I'm gonna leave.
both of you stop.
objection.
Both of you stop.
So we went into the.
I just asked a simple question. How far apart were you?
About $1 million.
That's a long ways.
It's a long ways. And the whole issue was, we had made some proposals that were based upon Doug being a seller, and then all of a sudden.
No, objection,
it
Your Honor,
came
the
back
court was
and-
clear,
and-
Your Honor, the court was clear. You are not, this court is not allowed to entertain any discussions regarding mediation. Now, first of all, this is inaccurate. Second of all, I have no way of proving it unless I get to bring Mr. Soretsky in here. If this court is going to entertain.
I don't need to go there.
Okay.
I was simply asking how far apart.
About $1 million.
That's a long ways.
It is a long way. And the issue here really
And
is.
was there ever, I know there was talk about an appraisal, but it sounds like the only thing that was ever valued was the real estate.
Right, and
Correct, Your Honor.
Ben Burchard of Stout Reeses, which is a very well-known valuation company, has taken the position that it doesn't want to put out valuations in small companies like this during the financial and COVID crisis, because you just don't know what's going to happen. And Mr. Bernard would like to
Hi,
argue
but
that
this industry, how much of the work is government as opposed to private industry? Does anybody have a sense of that?
yeah, it's 100% really private industry, but what Airway does is it takes orders from Eaton and
But it's aerospace industry.
aerospace, but then
And there's
for
a big
Boeing.
cloud hanging over that because airlines are suffering terribly right now.
That's right. And Eaton had laid off many of its union people, now is slowly bringing them back, but they don't know what's going to happen, and that's the problem. Yes, you had a series of very profitable years for the company, and then all of a sudden you had the COVID crisis. You can't go back and use the same measures you would normally use to value a company. And I'd just like to say one thing, Your Honor, and I was going to have Paul address this dissolution issue, if it would be okay. Paul?
I think the crucial point to remember here, and I'd like to take exception to something the opposing counsel said. The crucial point here is regarding this court's authority. Apparently, opposing counsel had some trouble understanding our opposition to the 7-day order. The linchpin of that opposition is the proposition that a court cannot order dissolution as an equitable remedy without specific kinds of findings and without establishing specific conditions, none of which have been established in this case. Plaintiff's claim in this case is under Section 1489, which provides for dissolution as an equitable remedy. They talk a little bit about Section 1541A, but that doesn't create a cause of action. It establishes a standard and it creates a limitations period, but it doesn't establish a cause of action. So the relevant statute here is 1489. And the cases we've cited in our opposition make it clear that you can't just order dissolution right out of the gate as an equitable remedy without going through the process of determining
It would be,
factual foundation. for
it
the
would
remedy.
be tantamount to granting summary disposition, is what you're arguing.
Exactly, Your Honor. And again, to correct something that opposing counsel said, he said our only claim of damages is termination. We filed an amended complaint because they had not given an answer to our original complaint. In the amended complaint, we specifically allege that this lawsuit and all of Doug's actions have harmed Rick's position with the company. So ordering dissolution is effectively granting summary disposition on our counterclaims and granting the the relief that Doug said he wanted and was entitled to under Section 1489. And, you know, if we're going to talk about what happened at the March 3rd hearing, let's also talk about the fact that this court concluded that Doug was unlikely to prevail on his claims. So if he's unlikely to prevail on his claims, and his demand is dissolution as a remedy, why is he entitled to dissolution now? Our position is that he's not.
May I respond, Your Honor? Your Honor, as this court knows, MCR 2.116I1 states, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay. I was fairly confident that's exactly what happened on March 3rd. This court looked at all of the pleadings that had been filed, everyone trading papers back and forth, saying, we can't get along, we disagree with this, we disagree with this, we don't have a third officer, we don't have a third shareholder, I mean, we have a third member of the board of directors. What is going on? Why are we going to go down this path unnecessarily? Is there a genuine issue of material fact? Here's the material fact. Does Doug Rogers have the ability to become unchained here? Is there a buy-sell agreement? No, there's not. There was one proposed by corporate counsel 5 years ago. My client agreed to that, but he could never get Ricky to sign it. He wouldn't agree. That's a pretty key issue. I don't know who drafted the original bylaws for the company long ago, but that's one of the things that started this off, is that they failed to include any type of a deadlock provision in the document. And there's no way to extract yourself. So,
Well, I'm a little puzzled. I thought I heard someone say earlier that there was some kind of right of first refusal, some form of buy-sell agreement in place. You're saying there wasn't?
there is a shareholder agreement, but that does not, that's the role as a shareholder. That doesn't have anything to do with the party's roles as directors and officers of the corporation. That's what we're talking about. That does not exist.
There's a shareholders agreement that says if you want to sell your shares, you have to first offer them to the other shareholder.
Exactly.
And
It's
we went,
Exhibit 7 to his complaint.
and we went through mediation twice, and without getting into numbers, there were offers made back and forth for both parties to buy, or both parties to either buy, be the buyer or the seller. We did that already. We did that twice. So to say, oh, there's a mechanism in place, okay, we get that, we agree, there's a shareholder agreement. We went through mediation in August of 2019. The mediator declared an impasse. We went through mediation again. Now again, the mediator, after several sessions, has declared an impasse. Both parties are tendering offers to be the buyer or the seller. So when I objected, it's because we're not supposed to talk about numbers in mediation. That's specifically prohibited by the court rule. But there were offers from both sides to be the buyer and the seller. To stand before this court and say that my client only wants to buy the company if he can get it for a song, or it's completely false. It's a lie. I'm gonna call it what it is. It's a lie. That's not true. This is why we have problems on the telephone, because this is not reality. What reality is both parties made offers to buy, both parties made offers to sell. We didn't reach an agreement. If the court is going to take the position after hearing that there's a shareholder agreement and that there's there's an opportunity out there to resolve it that way, well, I think that we've accomplished that, and we were unable to do it. And we need this independent counsel to step in, as counsel is suggesting, to step in and make decisions. That's a receiver. This court recognized that immediately. We can't get along. The parties cannot get along. Appoint an independent receiver. Let that person determine if they need separate legal counsel. They can be legal counsel for Airway. They can be legal counsel for Brit. The problem is, Your Honor, we had to list Airway and Brit as parties to this litigation, or this court doesn't have the authority to grant dissolution. If they're not parties, this court doesn't have jurisdiction over them. That's logical. And if the parties cannot agree on an attorney, then those parties will never be listed in a lawsuit, and dissolution would never be available. We have this catch-22. I don't have any interest in representing Airway and Brit forever. Let the independent counsel do that as the receiver. If the court says this is the receiver, and the receiver says I'm happy to appoint a different attorney, or I can handle it on my own, so be it. Let them do that. But you have to have them as parties, or this court is going to tell me, how can you seek dissolution of these entities? You didn't even bother to list them in the caption. We had to do something. They cannot agree on anything. That's the problem. That's what the statute calls for. So we would suggest, respectfully, that this court do what it said it was going to do on March 3rd. Issue a sua sponte ruling under MCR 2.116I1 that says, I've heard enough. We don't need to go through discovery. What more is there to prove? Ask. Does your client have any damages relative, do your clients have any damages relative to being terminated? Or weren't they immediately reinstated and didn't lose a dime? Because if that's the case, why are there still counterclaims out? Why haven't those been voluntarily dismissed?
Because my client has cost my client $100,000 in legal fees and costs for experts. And my client has provided this court with a declaration that states, as a 50% owner, I've always been responsible for the operations of the company, including full responsibility for customer relations, sales, and management of the company's production services, to product for sale, and the invoicing, and the payment for services for products sold. Our business has continued to be profitable. For 30 years, I have been responsible for obtaining customers, keeping those customers satisfied, which to this day results in Airway making substantial profits for my family and Doug's family. During 30 years, Doug has been responsible for certain limited administrative duties. There's only 9 employees. And I have the primary responsibility with both customers and employees to do the welding and shop work. If Airway is dissolved or a receiver appointed, they will lose their jobs and will adversely affect the city of Jackson in the state of Michigan. And then Doug and I have no fundamental organizational or administrative disputes operating Airway or Brett. And there isn't one scintilla of proof of that, except Doug wants to buy out Rick cheap. And that isn't the basis, because if the court looks at the law, I hate this. When the legislator enacted BCA former 450-1825-1, allowed the circuit court to adjudge the dissolution and liquidate the assets of a business for fraudulent, illegal, or willfully unfair and oppressive conduct on the part of a director or person in control of the corporation. Well, we don't have that here. If Doug wants to sell his stock, God be with him, to a third party.
I don't think that was the statute that Mr. Inocencio was arguing. The statute he was arguing says if there's deadlock and they're unable to resolve the deadlock, that would justify dissolution.
But there's no deadlock. The only deadlock is Doug wants to buy out Rick cheap. As dissolution is a very drastic measure, it is considered a last resort remedy. It's a remedy. It's not a cause of action. And there's contrary now, definite, always has been contrary evidence to any dispute between Doug and operating the company with Rick. They've done it for 35, 40 years. There's no letters, there's nothing. So all I'm suggesting, Your Honor, is that there's no basis for dissolution. There's certainly no basis for a receivership. There's no basis for Mr. Inocencio to keep representing the company. And Rick asked for relief under 1489 only. Only. He didn't ask for anything else. So at this point, the court is not kicking it down the road. There are legitimate claims by Rick for damages, probably in excess of $100,000 now. There are no dispute because there are 3 declarations, not including the prior declarations, that there's no dispute between the parties on how it operates. It's not like they're not making money. Now, maybe in 4 or 5 months, when the economy either collapses or gets better or whatever, who knows? I don't know if Boeing's going to go bankrupt or not. I don't know if Raytheon is going to go bankrupt or not. I don't know what's going to happen, and neither does Mr. Burchard at Stout Reese's. I think at the very least, we have an absolute right to take some discovery, and I sent twice to Bruce a scheduling order. Take some depositions, let's see what this basis for this dissolution really is. And then a subpoena to Bruce because of the Summer Schwartz case, and we will get whatever documents there are, and this is going to proceed as normal. Doug asked for relief under 1489 only. He never asked for what is now being claimed. And as dissolution is a very drastic measure, it is considered a last resort remedy. It is necessary to prove exceptional circumstances before dissolution will be ordered. These include financial loss, well, there's none. Corporate paralysis, there's none, it's making money. Doug goes and buys something, Rick doesn't object. Rick goes along with pretty much whatever Doug says. Mismanagement and deterioration of property, well, no. Doug goes out and buys new property and Rick doesn't say anything, new electrical, new welding equipment, whatever. The ultimate test is whether the corporate ruin will inevitably follow continuance of present management. There's no establishment of that, Your Honor. You just can't do that. I would suggest that you defer, except for the disqualification motion, ruling on our motions to dismiss. Maybe they'll amend their complaint, maybe they won't. Enter, I've asked Bruce to give me some dates for discovery, motion cutoff, etc. I don't know when there's going to be a jury trial for this case, Your Honor. I saw an ABA webinar with judges from across the country, and the issues of having a jury, you should have seen some of the courtrooms. They had plastic between them. And
we're a long ways from doing jury trials, so
yeah.
you can safely assume that.
Yeah, so it was pretty amazing. Pretty amazing what is going on. So I think that at this point in time, Bruce can't get what he wants because it's a remedy and he doesn't have a cause of action.
Your Honor, I know the court doesn't want to keep going back and forth, but I could have 30 seconds. I'll wrap up. Your Honor, you just heard counsel for the defendants say that we did not file a cause of action under Section 1823, that we filed under 1489. Your Honor, that's patently false. This is what we have to deal with, playing fast and loose with the rules. Count 3 of our complaint is for a count for dissolution of corporation. Paragraph 53 cites the statute specifically that I just read to this court, Section 823, which is 450.1823. That is exactly the statute that applies, and it is exactly what we alleged. You just heard counsel make a representation to this court that was completely false. I would also add that the statute is actually entitled, this is critical, action by director or shareholder for dissolution, semicolon, judgment, semicolon, proof. It is a cause of action. You just heard counsel argue that it's not. No case law to support that, no court rule, no statute, nothing. In fact, the statute that he said that we did not allege our case under, which we did, is actually entitled action by director or shareholder.
Does the statute say that the corporation is a necessary party to such a claim?
The statute does not. There is a case, and I do not recall the site off the top of my head, Your Honor, and if the court says I want to see that at some point in the near future, we could probably track that down. But I do recall reading a case that said that the court, and I'm paraphrasing, that the court did not have jurisdiction over the the company to be dissolved because it was not listed as a party to the lawsuit. That's the only reason we included it. If this court says, this court has jurisdiction to dissolve Brit LLC and Airway Welding Incorporated, and they should no longer be parties to the lawsuit, I don't think that we have a problem with that. The whole reason we became involved was to assist Doug Rogers and his sons with this process. I would like make one final point. Your Honor, we do have corporate paralysis. We clearly have corporate paralysis. And as much as counsel wants to suggest that we don't know what's going to happen with the finances in the future, we never know what's going to happen. Now, I recognize that things are a little crazier right now because of the recent pandemic, but the current state of financial affairs is not a basis for not dissolving or dissolving an entity. It may impact the eventual price that one of them pays or receives, but there's no expert needed for that. We don't have to wait until the economy resolves itself to determine what is going to happen. There's no case law for that. There's no statute that says that. These are just creative arguments, we'll call them that, but they're without legal basis. And if the court applies the law, which is what we want this court to do, which is what we asked for in count 3 of our complaint, and the statute provides for, it should be fairly straightforward that that is exactly what this court did on March 3rd. And we'd like the order entered to reflect that, and an appointed receiver. Thank you, Your Honor.
What unfortunately counsel forgets is B. As a result of a condition stated in subdivision A, and here's the test. Here's the test. The corporation is unable to function effectively in the best interests of its creditors and shareholders. That's the test. Well, they haven't met the test. We have contrary affidavit or declarations. The case law is contrary to what counsel, dissolution case law specifically says. Just because two people aren't happy doesn't mean you dissolve and ruin a corporation and destroy its wealth, because that's what's going to happen. The minute this company is dissolved, it's going to lose the Eaton business. That's a fact. They don't want to be involved. And that's why it has to keep going for the employees.
Let me stop you, counsel. On the issue of dissolution, I am satisfied that it would be premature for the court to order what in fact is the ultimate relief that's being sought without the grounds firmly established for granting summary disposition. I'm not prepared to do that today. At a minimum, there is a question of fact, even though it looks pretty soundly that there's a high level of contentiousness in this organization. Has the standard been met for the court to order dissolution under MCL 450.1823? And I think there's a question of fact remaining there, and it needs to be explored. I'm not going to be in a position of granting what in effect is ultimate relief at this stage of the litigation. I'm also going to order that both the corporate entities, the LLC and the corporation, be dismissed from the case without prejudice. If it becomes necessary for them to be involved, I'll deal with it then. That takes care of the problem of Mr. Inocencio's conflict. I don't know how much of a conflict it really was, because what we really have here is not a battle between the corporation and its shareholders. We have a battle between the corporation's shareholders. So I am going to order that they be dismissed. That removes Mr. Inocencio from a conflict situation. If it becomes necessary to bring them back in, I want to fully explore the issue of how in the world can an attorney effectively operate as an attorney for an entity where its two 50% owners are at odds. Who's going to give direction to that attorney? I mean, it's an impossible situation for an attorney to be in. The attorney's not the decision maker. The attorney is he gives counsel and he advocates. He does not make decisions because he doesn't have any skin in the game. It's not his company. That's not the role of an attorney. Sometimes they're put in that role by a client deciding to cede authority to an attorney, but involuntarily, that's an impossible situation. I am not going to dismiss the breach of fiduciary duty claims, although I will tell you, I don't think there's much to them. But again, that's premature. At some point, I may be called upon to dismiss those claims when it's in front of me on a no genuine issue of material fact. It's not here today. It's enough has been alleged for a colorable claim. The fact that I don't think much about it is not a basis for me to be granting a dismissal at this stage of the litigation. I'm just troubled that I don't know how much I'm going to help you folks. I hate to see, I felt the same thing when I carried this armload of files into the courtroom. What I was attempting to do when I said I'm going to order dissolution and appointment of a receiver is bring the parties to the table and get them to talk and get it resolved without spending a fortune on legal fees. And obviously that didn't get accomplished. I didn't help anything by the suggestion. But ultimately, I'm hard pressed to know how I'm going to be able to help you folks your clients reach a resolution that you can both live with. If you're $1 million apart at a sale price in what are clearly uncertain times for the aerospace industry, I can see difficulty closing that gap if there's that much distance between the parties. Perhaps one approach might be to get a third director appointed with some kind of authority to act as a director. I can see the challenge in finding somebody to fill that role because each brother is going to be suspicious of the other, and whichever person one suggests, the other will immediately believe, well, obviously that must be somebody who's got in his hip pocket. I can't approve that one. If there were a way to get a third director appointed or more, yes, counsel?
Could the court suggest some names?
I could, but not off the top of my head.
I understand. Because then there would, I mean, you're as aware of people in the local Jackson community that are knowledgeable in corporate business matters that could be an independent director. And my client's more than willing to accept that. A recommendation from the court of a name would be terrific. Or 3 names, or 2 names. It doesn't have to be done today, but.
I would want to ponder that.
Yeah.
and I can't force the issue. I
That's
can
right.
only say that might go a long ways to resolving these recurring conflicts between these two brothers, but how it gets you to a point of one buying the other out, and maybe that can't happen now in the current marketplace. I certainly sympathize if, and that's why I asked, is this military or is it private industry? But if Eaton's customers for the parts that Airways supplies are all private industry, there's got to be a huge cloud hanging over that right now. I mean, who knows what's going to happen to air travel in the future, even once all restrictions get lifted? Are people going to flock back to the... So let me give you a real recent example of that. So yesterday, my wife and I celebrated our 45th wedding anniversary.
Congratulations.
And thank you. I don't know how she put up with me that long. But we wanted to go out to eat. Nothing's open. So one of my secretaries suggested that I drive to Indiana, because there's some restaurants open down there. But somebody else came up with a better suggestion, which was the restaurants at the casino, Firekeepers, are open.
I like it.
So I made a reservation to make sure we could get in, because I'm thinking, this was yesterday, I'm thinking this restaurant's going to be packed. There isn't a single restaurant other than at a casino open. People are desperate to get back. This restaurant was at 50% capacity, I'm guessing. The tables were very distant from each other. I didn't need a reservation. I could have walked in and sat down. The half that was open was only half full. So if people are that reluctant to go out to eat when you could legally do it, how reluctant are they going to be to hop on a plane? There's a big cloud hanging over that, and probably not the best time to be selling a company when you've got that kind of uncertainty. So can these guys figure out a way to get along before, see what the future holds? One way to do that would be to get an independent director in who's got good business sense, knows the industry, doesn't have any kind of a relationship with either party. If such a person exists, I will certainly ponder that. But it's only going to be a suggestion. It's not something, at least at this stage, I'm ready to order.
Oh, no. Any suggestion would be very much welcome, Your Honor.
And short of dissolution, is there authority under 450.1823 for the court to order the appointment of an independent director?
I'm unaware, Your Honor, I'm unaware of the court's
I
authority to
just
do that.
throw it out. I've never even thought about the question before, so.
I've never seen that, Your Honor. I'm unaware of any statute or case that provides for that.
I mean, if I've got equitable authority to order the dissolution, I mean, like the heaviest resolution, do I have equitable authority to order something less?
I think, Your Honor, I think the court would be then stepping into the corporate bylaws and.
I asked the question, I'll give you a
Right.
chance to think about it. I certainly wouldn't order it without giving both of you a full opportunity to weigh in, because I don't want to be creating immediate grounds for appeal. But it strikes me as something that logically would be preferable to destroying this company. And I don't remember what all you guys had in front of me today. Is there something I haven't addressed?
Your Honor, if I could make a comment on the court's last comment, I think there's this misconception that that if we go through dissolution, that it necessarily will result in destruction of the corporation. If the receiver steps in, I've seen situations where the receiver steps in and finds a way to resolve it, and maybe that's the independent person. They have the authority. This court may not have the authority to make some of those decisions, but the independent person that this court appoints as the receiver does have that authority. And if that person says, I'm going to put this up for bid, and the two of them bid, one of them wants to buy, this is my bid price, one of my sales price, guess what? The company then continues on.
Well, the difficulty, and I thought about this before coming out here, as I was reading your briefs, the difficulty with a court-ordered sale or a receiver generated sale is when you have a sale of a company like this, there are covenants not to compete. And a receiver can't give that.
Understood, Your Honor.
Yeah, I agree, Your Honor.
And that's a real drawback. If a receiver were to negotiate a sale with a prospective purchaser, that purchaser is going to want a covenant not to compete from both principals to make sure they don't turn around and form a new company and go right after those same customers.
Unless one of the buyers is one of the principals.
Well, that one's easy, but what about the other one?
Well, not sure. Not sure. It's certainly less than a perfect solution, which is why we tried resolving it via mediation now twice. We recognize the difficulty.
Third time's a try, third time is a.
All right, so back to my question. You threw a number of issues at me today. Is there something I haven't addressed?
No. I appreciate your time, Your Honor.
All right. Somebody should submit an order this time.
I will prepare the order and submit it, Your Honor, within 7 days.
Fair enough.
Thank you.
Thank you.
If you could fax that to me, counsel, I'd appreciate it.
All right, Shannon, you can take us off the record, and I'll stop my recording.